Okay guys, next element, we need to determine whether the plaintiff has suffered damage. Okay, damage or injury must have been caused by the defendant's breach of duty. Just now, okay, we have fulfilled the second elements of negligence, breach of duty. Now, we need to determine what are the effects of breach of duty. Okay, so the plaintiff must suffer damage. So in order to determine whether damage suffered by plaintiff was the consequence of the defendant's breach of duty, we must look at two issues here. First is causations in fact. Okay, in order to prove causations in fact, okay, we will use the test of but for test. Okay, but for test. And then the second issue is causations in law. Okay, first causation in fact. Whether the defendant's conduct has in fact caused the damage suffered by the plaintiff. So we need to determine adakah disebabkan defendant plaintiff suffered damage. So the test to be used here is but for test, meaning in bahasa kalau bukan kerana. Okay, but for the defendant's breach of duty, the plaintiff has suffered the injury or damage. Okay, kalau bukan kerana defendant, adakah plaintiff akan suffer damage? If the answer is yes, then it may be concluded that the defendant breach did not cause the plaintiff injury and vice versa. Meaning to say that ada factor lain that caused the plaintiff to suffer the damage. Okay, and this test has been accepted as an appropriate method of deciding causations in negligent cases. Okay, the question, would the accident have occurred but for the defendant's negligence? Okay, betul ke accident tu terjadi disebabkan oleh negligence of defendants. If the answer is that the accident would have occurred even without the defendant's negligence, then there is no causation. Okay, maksudnya dia still akan suffer damage even kalau bukan defendant's negligence. This is how you assess the but for test. So this test was laid down in the case of Barnett against Chelsea and Kensington Hospital Management Committee. In this case, the three security guards went to the defendant's hospital, when they started vomiting after drinking some tea in the early morning. One of the security guards was the plaintiff's husband. The nurse on duty telephoned the doctor, who instructed the nurse to tell the three men to go home and call their own doctors. Later that afternoon, the plaintiff's husband died of arsenic poisoning, and the plaintiff sued the hospital for negligence for its failure to treat her husband. She argued that the hospital played responsibility, and the doctor had breached his duty of care for not treating the patient, but that breach did not cause the plaintiff's husband death. See, first and second elements of negligence may be fulfilled, but the third elements, the breach did not cause the plaintiff's husband death, as evidence shows that the patient would still have died even if the doctor had treated him. Even doktor tu cepat sekalipun selamatkan dia, rawat dia, the patient would still have died. And the defendant was not liable for negligence. So in this case, the hospital was not held to be liable. Okay, in regards to the second point, causation in law or remoteness of damage. This is where the plaintiff is required to prove that the damage or injury is possible or predictable. Okay, dia kena fulfill yang defendant foresee that damage tu akan terjadi. Okay, and a negligent act may give rise to different types of damage, but the law does not and will not impose liability on the defendant for every single damage that occurs due to his act or omission. So the most important thing here is whether the defendant foresee that the damage will happen. Okay, so if the damage suffered is not foreseeable and too remote means that terlalu jauh, maksudnya bukan direct damage, then the plaintiff will very likely to lose the case. So kalau dia tak dapat proofkan this causation in law, maksudnya the damage is not foreseeable by the defendant, then plaintiff will not win the case. Okay, there is a test basically, and this test is known as a reasonable foresight test. And the case here, landmark case for this issue, the wagon mount. Okay, what happened in wagon mount? The actual name of the case is Overseas Tank Ship UK Limited against Morse Docks and Engineering Co Limited. Nanti kalau you Google the wagon mount case ni akan keluarlah the citations of the case. Okay, in this case, the defendant chartered the ship named the Wagon Mount, which was anchored at Sea Oil Company for refueling. And due to the negligence of the defendant's stevedores, some oil had spilled onto the water and the oil spread to the plaintiff wharf, which was about 600 feet away. Two ships were anchored at the plaintiff wharf for welding works. And the manager of the plaintiff wharf, upon seeing the oil, ordered the welding work to stop. He inquired with the Sea Oil Company whether it was safe to continue with the welding work, and Sea Oil Company advised him that it was safe to do so. Then they proceed. Okay, the manager himself believed that oil on the water surface was not dangerous, but he reminded the workers not to drop any flammable materials into the water. Okay, so dalam air tu dah penuh dengan fuel. Okay, the oil, but they still continue the welding works. 2 days later, the oil caught fire and the plaintiff wharf was extensively damaged. Right, so now how the court decide at the trial. First, according to the experts' evidence, it was unforeseeable that fuel on the surface of the water would catch fire. Second, it was foreseeable that the damage by way of oil seeping into various parts of the wharf and affecting usage of those parts would occur. Okay, meaning that the damage in this case they think that the damage was foreseeable. And the defendant contended the damage was foreseeable, the type of damage which had actually occurred was not foreseeable. And the trial judge and appeal court held that since damage was foreseeable, defendant had breached the duty of care and was thus liable for all the direct consequences of that breach. So at the appeal court, the judges decided that the defendant had breached their duty because they foresee the damage would happen. And then the defendant appealed to private counsel. And at the private counsel, it established the test whether a reasonable man in the defendant's position would foresee the damage that has occurred. In this case, since it was not foreseeable that the defendant's breach of duty would cause a fire, the defendant was held not liable. So in this case, the defendant was not liable because the defendant failed to foresee that the damage would happen. Okay, so in this case, basically, a party can be held liable only for loss that was reasonably foreseeable. So kalau dia tak foreseeable yang akan ada damage, then the third element is not going to be fulfilled. So the test in this case is accepted in England and thought to be the correct one. Okay, and this is also approve the principle in the Wagamon Act and used in the case of Government of Malaysia against Jumat bin Mahmud and others. Okay, remember the facts of the case just now. The teachers was not foreseeable the damage that would happen. Okay, so I hope that you clear on the parts of causation in law and causations in fact. So just to remind you all that causation in fact means that plaintiff injury caused by other factors as well. So kalau you boleh fulfill causation in fact, maksudnya defendant is not liable. Okay, maksudnya plaintiff suffer damage bukan disebabkan salah daripada defendant sahaja, tapi ada faktor lain. But for causation in law, it is caused by sole factor only. Okay, the defendant breach. This is because the defendant foresee the damage would happen. Okay, so ada beza causation in fact and causation in law. If you are able to prove the causation in fact, the answer is yes, then defendant is not liable. But if you are able to prove causation in law, then the defendant will be liable. Later we continue with the defenses.